welcome to Legally Speaking with me, Tarun Nangia. Justice N.V. Ramana, the Chief Justice of India, and Justice Sanjay Kishan Kaul made two important statements in the past 2 weeks. We heard Justice N.V. Ramana admitting that about 3 in 4 people in jails are under trials. And sometimes that number is more. If you look at it in percentage, up to 80% of people are under trials. And that is a matter of concern which he raised. And also we heard Justice Sanjay Kishan Kaul speaking about that the center, the government, the parliament should think and mull over drafting a new bail law. And he seemed very concerned about this. Why we discuss this issue today is because we would see time and again that many times businessmen are put in jails, but that's not where the story ends. The businessman doesn't get impacted. He's unable to pay salaries. He's unable to service loans because in many cases, Indian businesses are family run. If you take the top guy out, then the whole edifice collapses. And it has an impact on the economy also. So putting people in jail has got a ripple effect. And that is why for India to grow at 8%, we have to understand that punishing people is okay. But before that, if people spend months in jails, what happens to businesses? Also, we'll discuss what happens in other matters where under trials of petty crimes are also put in. That aspect we'll also discuss. But it is important because Justice Ramana and Justice Sanjay Kishan Kaul raised this. I have a very eminent panel with me. May I welcome Justice Arjun Kumar Sikri. He's just back from Singapore, where he's a judge at the Singapore International Commercial Court. Thank you so much and good to see you again. I have with me Senior Advocate Amit Desai. He joins us from Bombay. Good to see you again, Mr. Desai. I have with me Senior Advocate Saurabh Kirpal, joins us from Delhi. Good to see you again, Mr. Kirpal. And at the outset, in the first 2.5 to 3 minutes, may I request Justice Sikri to, in a sense, distill what these two judges meant, and then we go ahead with the discussion. Sir, over to you.
Thank you, Tarun. As you have yourself paraphrased, I think it's a very, very important issue, bail, and from two angles. I mean, another dimension which you have added. First is, and we have to keep in mind, when we talk of bail, and that too of under trial, and under trial is a person who is facing the trial and he has not been sentenced so far, correct? And we have the cardinal principle of criminal law is that a person is innocent till he is convicted. So therefore, as when he's facing trial, he is not a convicted person. And in this context, this freedom of the person or liberty of a person becomes paramount. So therefore, bail, and in any case, because although this is given or these are bail applications are considered at the initial stage by the trial courts, but these raise the fundamental issue of liberty of a person. And this liberty, which is a fundamental right guaranteed to every citizen under Article 21. So that is insofar as that individual is concerned. Other aspect or other dimension which I said, which you have highlighted, is the social effect of this, particularly in the case of economic offenses, and where the industrialist or other persons who are charged for such kinds of offenses, they are facing a trial, and if they are not granted bail, what is the effect that on the industry, on the society, on the economy? So therefore, bail, if we examine the matter in this context, it becomes very, very important issue. Now, as I have said, that a person till the time he is not convicted, he is deemed to be an innocent person. I mean, it automatically follows. He cannot be deprived of his liberty and freedom unnecessarily or without any reasonable cause. And when we keep that in mind, of course, we have the provisions that a person who is charged for an offense can be arrested as well. We are not saying that the person cannot be arrested at all, but the parameters, the reasons, etc., and under what circumstances, I mean, a person can be arrested, they are all stated in our our code of criminal procedure. I will not go into detail. My two esteemed panelists may, deal with that aspect. But what I'm trying to highlight is that because of these reasons, it is, bail, the fundamental principle or cardinal principle is grant of bail is a rule and denial of bail is an exception. Justice Krishna said way back in 1979, and which is, we remember even today, and judiciary keeps on repeating it, when he started a judgment, bail, not jail. And I think these bail and not jail, or bait, not jail, these three words capture the entire jurisprudence of bail. That normally, as I said, this is. So therefore, and there are judicial pronouncements also that normally a bail should be denied in a case where you have the apprehension that if the person is released on bail, he may temper the evidence, or he may threaten the witnesses, or he may flee the justice. That is, he may not appear in the court when he is called upon to appear in the court as and when the dates of trial are there and he has to appear. So only in these circumstances, a person should be denied. Otherwise, bail is a matter of right. But although this law is very clear and this law is there, which is reiterated time and again for the last 50 years, the problem is the way the judicial discretion is exercised in given cases, particularly in such cases where the so-called crime, because at that time, a crime for which a person is charged, he is not proved guilty, as I said, but it appears to be heinous crime. Or if it is an economic offense, it appears to be an offense of high magnitude, etc. So therefore, many times judges are being influenced by these considerations and they would deny the bail. Interestingly, even after some time when the bail is granted to that very person, 6 months, 8 months, if I give you the example, 2G cases, where the persons were given bail after 11 months. So in that judgment, when the bail is granted, a full lecture would come of judgment running into 40, 30 pages again, justifying the grant of bail and telling the entire jurisprudence on bail. But if that was in the mind of the judiciary or the particular judge, why it was not given in the first instance, why a person was languishing in jail. This has happened in Zubair case also. Recently, I'm talking about when the district court granted the bail, and district court said in that case that healthy democracy needs dissent. And that was known to them on the very first day also. So why you, after 28 days, when you grant the bail, at that time you state all this? So therefore, the manner in which judicial discretion is exercised, that has to be kept in mind. And I'll only take a few seconds and tell in the context of you have said about Justice Ramanna's statement and Justice Kaul's statement. Justice Kaul has now stated so through his judgment, and which are really laudable, no doubt about it. And Justice Ramanna gives this message again as far as under trials are concerned and what is happening. And Justice Kaul has tried, he has made an endeavor that judicial discretion should be exercised in a proper and objective manner. And the guidelines which he has laid down about the timelines, etc., also about no unnecessary judicial remand, and the procedure should be followed under section 4041A to avoid unwarranted arrest where they are given and where the bail conditions could not be met and the person, in spite of granting bail, doesn't come out. In those respects, I think if these are followed and these are implemented, it may go a long way in streamlining the judicial discretion. So those will be my preliminary comments.
Thank you for laying the ground and setting the agenda for today's discussion. I'll go to Senior Advocate Amit Desai. Sir, you represent some of the top industrialists of the country time and again in matters before the Bombay High Court, before the Supreme Court. And you come up with arguments which many times where you say that why this industrialist or businessman needs to be kept out. And I would like to point out an anecdote to you. Many times when businessmen are found that they attempt to run their businesses from inside jail, it's just an attempt to run a business. They are desperate because they know without them the business will collapse. Keeping that in mind, what comment will you give as your opening comment for today's discussion?
So Tarun, I think this is a conversation on personal liberty which must take place very, very, very frequently in this country. This conversation has been taking place in the judiciary for the last 50, 60 years. And despite the Supreme Court sort of settling the legal position again and again and again and again, the question is, why is it that the message of the Supreme Court is not being followed by the subordinate judiciary? It is not the function of the Supreme Court to be the bail court. And that also the Supreme Court has said. But what one sees as a matter of reality in the recent past is even the Supreme Court is feeling very sort of constrained that it has become a bail court, and which is tragic. In fact, every few years, and as Justice Shikri mentioned, I still remember that issue of the Sanjay Chandra judgment in 2G, where once again we have an entire thesis on the bail law. But it is all about how the Supreme Court wants to continuously send the message to the subordinate judiciary that these are the principles, please follow them, and do not burden the higher courts with bail applications. There are far more important and serious matters to be addressed by the Supreme Court, and even that, for that matter, by the High Court. So there is a problem, and the only way we can attend to it is, one, by a continuous conversation on the subject, a continuous reaffirmation. And I believe there has to be a lot more done, because in fact, I would just say that Justice Kaul's attempt in this whole process of this until guidelines, and I was a part of that matter, and so I'm aware of what was in his mind. He was very, very keen to actually declog the lower judiciary from all the bail applications. He wanted to actually find a simplified process where it makes it easy for the trial courts to follow these guidelines and take quick decisions rather than have these very long arguments in these matters. And that was his objective, and therefore he has actually, I think, done an excellent job in articulating the principles once again. I think the question for the courts now, as I see it, is that these guidelines must now be enforced. It should not be just one more of those judgments, hundreds of judgments of the Supreme Court, which talk about personal liberty, which talk about bail law, which talk about bail, not jail. All these principles are too well settled. They're not only settled in India, they're settled in many of the Western democracies from where we've adopted our principles on the rule of law. Now, how do we take this to the next level? Because when you bring it up in the context of the reality of today's economic reality, unless this message is sufficiently entrenched in the minds of the subordinate judiciary was to deal with this problem on a daily basis, this is going to be only another conversation piece. So the question for us, if I may sort of want this debate to continue, is how do we get the Supreme Court, which has started this process, to complete the process by ensuring that these guidelines are now actually being implemented by the trial courts. So fortunately, the Supreme Court, in fact, in the context of 41A, which was a provision that was introduced now nearly about 15 years ago, and in fact, it was introduced after a judgment of the Supreme Court in Joginder Kumar, which was of 1995, where also they said that you should ordinarily not effect arrest, etc. The law was amended to actually control the power of arrest, and it was never being followed. And once again, they've reaffirmed it. How do you get down to the basics? So the Supreme Court has this time directed that all states must frame guidelines in relation to 41A. And fortunately, the matter is kept pending for compliance after 4 months. So the question is, can we use this opportunity to ensure, and I think Justice Kaul at least was so inclined to try and make sure that the courts now will follow this. So at regular intervals, I think the effort has to be to go down. Now, why is this so important in the context of the growing economy? You're right. One is, of course, and we cannot forget that a large majority of the under trials are coming from, poor families, and they have to be also dealt with. Many of these situations are also for them. But the economic side of it, which is where a lot of your viewers are and your show is relating to, the economic side of this matter is exactly what you're saying. Because when you find promoters and entrepreneurs who are sitting in jail on commercial transactions, where an investigating officer has an opinion on whether that commercial transaction is actually an offense or a fraud, or it is actually a commercial transaction which has been undertaken in the ordinary course of business. So you have a officer who may not understand all aspects of business, making a judgment call that this particular transaction is a transaction which is in the nature of a fraudulent transaction, arrests the promoter or the entrepreneur or the CEO of the organization and takes him into custody. Now, when you take the top man in, as you rightly said, it disrupts the entire organization. And there is not only a presumption of innocence, but in commercial transactions, a lot of the courts are not fully acclimatized to commercial matters. They are not commercial courts where you have specialized judges who understand commercial transactions, who understand the distinction between what is a fraud and what is a pure commercial transaction. So the tendency is that when you have large numbers thrown at them, as Justice Sikri rightly mentioned, it creates a psychological pressure to say, oh, this is a very serious matter. So you always throw up hundreds of crores. It's a very large number. But the question is whether those hundreds and thousands of crores are all a fraud, or the fraud is only a small component of it, and the rest of it is actually some legitimate business transactions, which is when, like it happened in 2G, at the end of the trial, after nearly 8 or 9 months of custody, everybody was acquitted. So one doesn't know at the end of this.
And if I may add, they were ultimately acquitted by the trial court also.
By the trial court, acquitted by the trial court, who kept them in custody. Now, how do you balance this? Because you're absolutely right. This is an economic implication that people, the morale of the organization suffers. The employees then start looking for jobs elsewhere. They tell that the families of the employees also say that we don't want to be you to be associated with an organization which is involved in these kind of activities. So it actually starts having a significant impact on the business itself. And one is there is a presumption of innocence. In fact, Justice Kaul has reaffirmed what is stated around and what is known to even a college student and probably even a man on the street, that in India, we have the concept of a presumption of innocence. But yet, how do you balance off that presumption of innocence, that presumption that a transaction, unless it's in an exception case, obviously a fraud, how do you determine that there's a presumption of commerciality to a transaction and the court would say, I'll grant bail at this stage. We will determine once the total evidence comes before the court in the course of trial as to whether that transaction was a fraudulent transaction, for which, of course, the man must be convicted. But if not, then at least he's back in his office running his business. So his business doesn't suffer. And he's then available to face the trial. So this is the next level of balance. And I must tell you a very interesting thing that Justice Kaul has done is very, very important. There was an attempt by the government to create a separate class of offenses in the course of this discussion before Justice Kaul called economic offenses. And at a point of time, a suggestion was being made that in relation to these economic offenses, let's put a monetary figure in order to decide that where bail should ordinarily be granted, where bail may not be granted and should be left to the trial court. Fortunately, Justice Kaul has categorically in the judgment said that the legislature does not have any concept of an economic offense. It's not a separate offense. It's not a separate class. And therefore, it should not be treated separately. It's just like any other offense that takes place.
Point well taken.
Fortunately, I think that mindset needs to change, that economic offenses are a different category and therefore people should be in custody. I think is very important.
Thank you for sharing your opening comment in detail about the issue of liberty and bails and how businesses are impacted. I'll go to Senior Advocate Saurabh Kirpal. Now, in the city of Delhi, Mr. Kirpal, you are often seen representing a lot of business houses, industrialists, and many times the issue of liberty is what you argue before the courts of law. And then after that, when you see comments coming from Justice Sanjay Kishan Kaul and Justice N.V. Ramana, what runs through your mind and what needs to be done in your view if we want a business environment is in country where promoters know that, of course, if they are guilty, they'll go to jail, but they won't go to jail before the guilt has been found out.
Absolutely. I think one aspect of liberty is, of course, bail. But before bail happens, there is something else which precedes it, which is the arrest. And that is something that Justice Kaul and Justice Sundaresh have said in their judgment. is that it's all well and good to look at bail and we can discuss that. And that's the subject matter of today's discussion. A large part is the fear psychosis that is created through hanging the Damocles sword of arrest.
Yes.
Every business person who may or may not have indulged in some illegality, who's under investigation, who may have taken a commercial decision, which with 2020 hindsight looks bad, now faces the threat of arrest.
Yes.
And to run a business with a big brother or the CBI or the ED or some other enforcement agency looking over you, thinking that you might be arrested at any point of time, does not permit an active businessman to focus on their business. But they're running around lawyers such as myself and Mr. Desai. I mean, we are fortunate for it professionally, but that's hardly good business, hardly good for the country, right? So rather than focusing the creative energies on matters which should be focused on, which is running their business, creating further wealth, they're now concerned about not getting arrested. Once, if they are arrested, because they inevitably are, it seems that people have forgotten as to what is the purpose of arrest. We always say that bail should be granted in such and such instances, but the bail is just the flip side of the coin of arrest. You only arrest a person when it is necessary to do so, when you need their presence for some investigation, or you think they're going to run away. Now, the corollary of that is, if you don't need someone for investigation, or they're not going to run away, then you must grant bail. So the same mindset that exists in the investigative agency when they arrest without any cause, unfortunately, has carried on at the post-arrest stage in the subordinate judiciary as well. So the way the investigative agency doesn't care, even the subordinate judiciary does not often bother about what is the reason we are keeping people in prison. As Justice Sikri said, there is a presumption of innocence. Person is being tried. The person is not yet convicted. What is the point of keeping them in jail? The only reasons are if they're going to intimidate witnesses, if they're going to flee justice, or they need it for further investigation. Now, this does not happen. There is no reason whatsoever to keep people in jail. Now, so that starts a second agony of a business person, is that even if there is a businessman, for instance, the main person goes into custody, the rest of, and we have often family businesses, the rest of the family now, rather than focusing even more on their business, which they're required to focus on, right? Because one main person has gone now, you need all hands on deck at this point of time, because you need to run the business. Now, rather than doing that, they start going to making circles of the court, because they're trying to get bail, because bail is not being given. So first the wrongful arrest, and then a wrongful denial of bail starts happening. So the entire family, the employees, the entire focus of the business, and of course, often money is used by businesses to pay the high fees of lawyers, etc. And the money comes from a business, is then again diverted. So rather than focusing on running a smooth business, we have a problem where a denial of bail causes this issue.
Thank you for sharing that perspective with the viewers. I'll now read out point number 39 from Justice Sikri's Shakti Sugar Mills case judgment, which is one of the most often cited judgments of sirs. This point number 39 is very interesting, where he says, although law and economics traces back to the period of Jeremy Bentham, that is in the 18th century, in the last few decades, interplay between law and economics has gained momentum throughout the utilitarian theory, which is essentially economic theory in the world. Indian judiciary has resorted to economic analysis of law on an ad hoc basis. Time has come to consider the interdiscipline between law and economics as a profound movement on a sustainable basis. These are the additional relevant considerations which have weighed in our mind in adopting a particular course of action in instant case. Sir, what went through your mind when you were authoring this? Because clearly you are saying that law cannot be completely delineated from economics. And how would you connect it with liberty and bails?
Yeah, Tarun, actually this judgment in Shri Shakti Sugar Mills, which I had rendered, Of course, that was a civil matter, not
Civil matter,
a
yes.
criminal matter. But my emphasis was that judiciary has to keep in mind the economic effects of any judgment which is given.
Yes.
And how it is going to have whether it would be a positive steps for the progress of the or the sustainability of the economic of the country, or the advancement of the economy of the country, or it would be a regressive step. Of course, as I have mentioned in the judgment, ultimately judge has to decide in accordance with law. If a person is not entitled to any relief, that doesn't mean relief should be granted only by looking into the economic aspects. But having said so, when law is also in his favor, it becomes an added factor. And I am happy to note that, Tarun, and I will admire your ingenuity here, that you have been able to think about this principle, which is all the more relevant in the context of bail jurisprudence as well. And as we have said in the beginning itself, those were my remarks, that it is not only a question of the freedom and liberty of a person, but it's a question, granting or not granting bail, particularly as far as businessmen are concerned, who are charged with some economic offenses and they are still under trial, and what are going to be the consequence of that. I think judges will have to keep that also in mind. And Saurabh has raised a very, very pertinent point in this behalf. Today, it is, as he has said, that the bail is comes at a second stage. First is arrest itself. Whether arrest at all was needed. If a person, I remember having given one judgment that if during, sometime what was happening, many times during investigation, a person is investigated, either it is ED or CBI, and the person is summoned time and again, investigation is over. Now charge sheet is filed and the person is sought to be arrested now. So I said in that judgment, look, investigation is over, charge sheet is filed. During all this period, you did not require his custodial presence. You did not want to arrest him. What is the purpose of arresting him now? So therefore, sorry, if the person is not arrested during investigation, you cannot arrest him later on. So, these are very, very important aspects. And as I said, and these are to be now looked into from this prism, that look, if there is an industry or a particular enterprise, how it is being run, what kind of serious charges are there, if at all. Actually, problem is, if I may tell you very frankly, and we were saying psychological pressure on judges. Many times what happens, whenever such a person is arrested or even summoned by the ED or CBI, because these are high stakes matter, I don't deny that. But then the way it comes in media, and the person from very day one is branded as a criminal.
Yes.
So therefore that is at the back of mind of the judges also, though, if we give him bail, or if we say that no remand in the beginning itself, no, it may not be understood differently, and they have their own constraints. But having said so, what you are trying to say is, and I wholeheartedly support that we have to see, in the case of when the economic offenses are there, businesses are involved, in contradistinction to those who are say what we call professional criminals, and those who keep on committing crimes.
Yes.
And the parameters are totally different. But here, when the business is involved, it has the impact on the economy also, business also, employment of the people also. And it is not only, like Saurabh said, that if one person is arrested, other are, instead of concentrating on the business, are running after. If I may add, not only running after and trying to save that person who is arrested, they are also fearing that they may not be arrested tomorrow. They may also not be arrested tomorrow. So they are trying to save themselves as well. So entire concentration is on the case, and the business is, and I may add one thing more, that in case there is a fear that if a person is released on bail, he is continuing the business And if he has committed some frauds, he may not, continue with those frauds. But then today, we have enough mechanism in place. We have, suppose a person has duped a bank. That is a charge for 2,000, 3,000 crores of rupees, etc. But then we have IBC. Then this is this Insolvency and Bankruptcy Code. Those banks would go to the NCLT, will file the case, and in that case, the administration or the of the company will be taken away from those promoters and will be given to some that we appoint. NCLT appoints what we call resolution professional, etc., and all that mechanism is provided so that business is saved also, and at that same time, so person is prevented from continuing if there is any threat or there is, the charge is such that he may, or the apprehension is such that he may continue with those frauds. That situation can be taken care of even otherwise, while saving the business at the same time. So why arrest in the first instance? And even if arrest was needed and investigation is complete, why a person should not be given bail?
Thank you for sharing that perspective with all of us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.